Good morning, and thank you for joining me on the Path to Liberty. I'm Michael Bolden with the 10th Amendment Center, and this is the show for Wednesday, February 14th. Happy Valentine's Day, 2024. And today I'm talking about civil asset forfeiture, legalized government theft. Not explaining what it is. We're just going to assume you know what it is and what the problems with it are. But I want to focus primarily on another strategic failure. That is, of trying to get the federal courts to protect everyone's liberty in one fell swoop. It's like a Hail Mary, and I feel like a lot of times it makes things worse. And I want to kick it off with this article that we just published, I believe just earlier this morning, by Mike Meharry. And he points out, it's titled, 5 Years Later, Supreme Court Decision Still Hasn't Significantly Limited Asset Forfeiture. Surprise, surprise. He said, many people believe the Supreme Court, quote, ended asset forfeiture with its 2019 opinion in Timbs versus Indiana. We saw this all over the place, where people were saying, oh, civil asset forfeiture has been ended by the federal courts. Everything's all good. And that in and of itself is an issue that I'll mention a little bit later as well. But as we argued at the time, Mike writes, Timbs ended nothing, and follow-up cases about this actually bear this out. Now, here's an episode that I did. This is 5 years ago. Wow. I went to government-run school. My math is terrible. I used to use a phone or something, my fingers. Asset forfeiture was not ended by the Supreme Court from February 25th, 2019. I have not listened to it in quite some time, so hopefully the info in there is pretty solid, but I've got an update on what's going on that today. Now, despite the fact that civil asset forfeiture was not ended by the federal court system, a lot of people actually believe it was. And they argue that, they in essence argue that bills to stop civil asset forfeiture on a state level are a waste of time, and they don't do anything. Sometimes they just do nothing. Sometimes they argue against, like, what's the point of even doing this? And like, for example, here, Steve Williams in Hawaii, I'm not sure who he is, but he shared a link to an article over on X that we published about a pending bill in Hawaii to restrict civil asset forfeiture on the state level and then opt the state out of the vast majority of the federal asset forfeiture program known as equitable sharing. And here's the first response, and this is a very common one. Sarah says, I'm dying, not my Sarah, but this one. I'm dying to know how Timbs versus Indiana didn't stop this. Both RBG and Thomas cited back to the Magna Carta and Reconstruction articulating the levels of illegal this is. Now, they certainly made some statements about how they see the whole thing as very dubious, probably illegal, etc., but the Supreme Court didn't strike things down. We've got the whole case here. If you want to read the syllabus and the opinion, I will have that linked to in the show notes over at 10thamendmentcenter.com/path to liberty. Timbs versus Indiana in 2019. But a little background is pretty important so you understand what was going on, what the strategy was all about, and what it has led to, which is, I think, a bad result. Tyson Timbs of Indiana received a cash sum of money from his father's life insurance company upon his father's death in early 2012. Of the money, he used about $42,000 to purchase a Land Rover, a vehicle. However, Timbs, who had been a former drug addict, fell back to drugs following his father's death. That's a pretty common thing, I guess, and spent much of the remaining sum on illegal I don't know what the total sum that he spent on illegal drug purchases, but he bought this car, and then he got back into drugs. Addiction just kind of does that thing with people. So he fell back to that, and then he blew all the loot on illegal drug purchases, as well as participating in drug sales to support his habit. Because, I mean, if you know addicts, like I've known addicts over the years, like, it doesn't matter how much money you give them, they always run out, and they have to get involved a little further if they continue living. So Timbs ends up getting arrested. Surprise, surprise, drug war stuff. Rather than treatment, he gets arrested by undercover officers during one such sale in November 2013, selling approximately $225 worth of drugs. So he got arrested for selling a couple $100 worth of a product that the government considers illegal. He pleaded guilty to the charges, so he admitted he did it. He didn't actually try to get out of nothing, and was sentenced to a year of house arrest, 5 years of probation, and $1,200 in fines. He paid it. He actually served his time the way he's supposed to. But wait, there's still more to the story. The state, however, state of Indiana, of course, governments are pretty evil. They also used their civil asset forfeiture law to confiscate the Land Rover as a civil action. So basically, civil asset forfeiture, the short version is, if they can make the claim that they believe that something was used in furtherance of a crime, they're going to confiscate it. There's no due process, no nothing. They're going to confiscate it. Sometimes there's even been cases like the state of Texas versus a Chevy Silverado. Like they're charging the property with a crime in essence, and you have to somehow prove that it was involved in a crime in order to get it back. And that almost never happens. A lot of people who get involved in these things can't afford it. Of course, Mr. Timbs ran out of loot and he was trying to sell drugs to support his own habit. There's no way he could fight this. But he used this, so they confiscated his $42,000 vehicle because this was basically the tool of like a cartel or something. I don't know what their mentality was, but they're government. So their mentality is rip people off every chance they can get. So Timbs ends up getting represented by people who we consider friends, people we think are really awesome when it comes to civil asset forfeiture, understanding the issue and the problems. They do a great report on it every year, ij.org. But they filed suit against the state. But get this, arguing that the seizing of the vehicle violated the Eighth Amendment's prohibition against excessive fines. Interesting. Let's read what the Eighth Amendment says. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Now, I would say that a guy who sold $225 worth of drugs, got arrested for that, paid his fines, paid $1,200 worth of fines, had a year of house arrest, 5 years of probation, I believe the number was. And then they take the car, the $42,000 car. And, you know, if you read through the story a little bit more, it really made things difficult for him to get back involved in society. Of course, he had a conviction on his record, so it was hard enough to get a job. He ended up having to borrow somebody else's car to go back and forth to work. He had no public transit or anything to get there. So this really made it much more difficult for him if we're thinking about the human injustice involved. But the notion that $225 a conviction and then the $1,200 fine, somehow he's also got to pay another $40,000 giving up his vehicle is, I would say, it is an excessive fine. It is also cruel and unusual. But interestingly enough, there's an almost exact same provision in the Indiana State Constitution. It's Article 1, the Bill of Rights, Article 1, Section 16. Excessive bail shall not be required. Excessive fines shall not be imposed. Cruel and unusual punishments shall not be inflicted. And they add this a little bonus to it in the Indiana Bill of Rights. All penalties shall be proportioned to the nature of the offense. So his fine was $1,200. And so according to the fine system in Indiana, the proportion to the nature of the offense was a $1,200 fine. So what is that, like 5 to 6 times the amount that he was charged with? Not $42,000, which is pretty considerate. So rather than suing under the state constitution, they sued in state court, claiming that the federal constitution, the Eighth Amendment, prohibits them from doing what Article 1, Section 16 of the state constitution already prohibits them from doing. You got to think, like, why did they do that? Why did they need the federal government to come in and protect the people of Indiana, or in this case, Mr. Timbs, Tyson Timbs? Why did they need the federal government to come and protect him under the Constitution for the United States when there's the same provision, even maybe a little bit stronger, in the Indiana State Constitution? Check this out. A Grant County Superior Court judge ruled in Timbs' favor, finding that the value of the Land Rover was over 4 times the maximum penalty Timbs could have been fined. So there are judges in Indiana who already thought that this was an excessive fine. The maximum amount he could have gotten for his criminal activity was a $10,000 fine. So this was 4x that, 3.5, whatever it may be, a crazy amount higher. And they're saying, like, look, this is excessive. And then this judge particularly said, well, but they didn't sue that it was excessive under the state court. The question before the court was whether the federal constitution applied. And this is where it created problems, not just for Timbs, but I think for activism to stop civil asset forfeiture. And hopefully this will make sense as I go through the story a little bit more. So this was over 4 times the maximum penalty Timbs could have been fined. and 30 times over the fines he actually paid, and thus was an excessive fine in the context of the Eighth Amendment. But again, the suit wasn't under the context of the state constitution, so the judge wasn't even considering that. So the people who filed the lawsuit created an environment where they're only looking at it under the Eighth Amendment. A court of appeals agreed with this. So, of course, the state appeals this. They're saying, well, we can do whatever the hell we want. That's what they do. They appealed this ruling, and the Court of Appeals agreed with that county superior court, saying, yes, it was excessive. And yes, the Eighth Amendment applies to the states. However, the Indiana Supreme Court, the opinion was reversed. And I think they all knew they were going to lose. Everyone involved. Maybe Mr. Timbs had no idea of the legal process. I don't know anything about him personally. I've only read about this story off and on for a number of years. But I think anyone with any legal expertise, they absolutely knew that at some point the Indiana State Supreme Court was very likely to rule against them. Why? And we'll find out why. The Supreme Court reversed the decision. They argued that the Eighth Amendment only applies for federal actions and does not prohibit state or local laws from imposing excessive fines. Why? Because the Supreme Court had yet to issue any decision that incorporated the excessive fines clause of the Eighth Amendment to the states. This is absolutely true. Whether you agree with it or not, the fact of the matter is, under the case at hand, the question was, does the federal Constitution stop the state of Indiana from actually doing this because it's excessive? Now, the state constitution does prohibit it, and certainly there were two series of judges that said, well, this is excessive, and here's why. But because they weren't considering it under the state constitution, they actually had to look to federal court precedent and something that we call the incorporation doctrine. And I'm not going to get into any details on this really here today, but here, just a quick overview. Cornell Law School describes it like this. The incorporation doctrine is a constitutional doctrine through which parts of the first 10 amendments of the United States Constitution, known as the Bill of Rights, are made applicable to the states through the Due Process Clause of the 14th Amendment. There was no one at the founding that thought that the Bill of Rights meant that the federal government was going to protect people in the states from violations of their liberty on the state level. No one thought that. It was through incorporation and something called selective incorporation why we have this today. Whether you agree that it's a legitimate thing or not, I know a lot of you probably know that my take is that it is not, but we can get to that in another episode. But so this is also specifically addressing selective incorporation. And here from Cornell Law, they describe it like this. Rather than find that the Due Process Clause incorporates all of the Bill of Rights, so when they started doing this around 1925, if you think about the 14th Amendment, this is the late 1860s. And then up until 1925, no one was really applying the Bill of Rights to the states. This was a legal doctrine really created out of thin air by the Supreme Court. That's how I view it. Now, some people say the Supreme Court had just gotten it wrong and they finally started correcting their error in 1925. That's fine too. But the end result is that they only did what's called selective incorporation. They started applying various parts of various amendments one at a time when a case came up. And none had come up by 2012. So we know at this point there had been no cases where the Supreme Court said that this excessive fines part of the Eighth Amendment applied to the states. So they knew this when they filed the case. They think they were trying to set a precedent. So anyways, back to this at Cornell Law. Rather than find that the Due Process Clause incorporates all of the Bill of Rights, the Supreme Court supported selectively incorporating rights that the court finds is essential to due process. So they're calling this selective incorporation. Under selective incorporation, SCOTUS incorporated certain parts of certain amendments rather than the entire amendment at once, or even the entire Bill of Rights. And surprise, surprise, Wikipedia actually has a pretty good overview of how this has gone down over the years. I will have this linked to in the show notes over at 10thamendmentcenter.com/path to liberty. But this is a section that gives you a quick overview and a bunch of reference links to where they started incorporating parts of the Bill of Rights to the states. So the First Amendment primarily through the 1930s and the 40s. The Fourth Amendment not till the 1960s. The Second Amendment, the Supreme Court didn't do this until I think the McDonald case in 2010. And the Eighth Amendment had never been incorporated. And everyone involved in this lawsuit knew this. So when the Indiana Supreme Court ruled against them, I don't think should have been really much as a surprise, even though I wasn't following it close at the same time. Now, keep in mind that the Indiana Supreme Court did not say that the forfeiture was not excessive. The case was primarily that they're just saying, well, we're just following what the Supreme Court told us, and the Supreme Court hasn't made a decision on this. So we've got to overturn this, and if you want to change that, you got to take it up to the Supreme Court. So my question would be, if you know that's going to happen, why go that route in the first place? And I think there is a probable answer, and I think the goal was less about protecting the liberty of this individual and more about establishing a precedent, establishing that another part of the Bill of Rights is incorporated against the states, this time part of the Eighth Amendment. So basically, this is trying to create another scenario, like with the right to keep and bear arms and with privacy, where liberty ultimately, where your liberty, where the power of government to violate your rights, to steal stuff from you, ultimately depends on 5 unelected, unaccountable, politically connected lawyers making up a Supreme Court. It depends on these people in the federal government being the good guys. And I think this is a very bad strategy. Now, I covered this in some detail. I did a whole episode on Monday talking about how this type of strategy runs completely counter to the founding generation of how to approach things, relying on the federal government to limit the powers of the federal government and the states. I would say that because people have been doing this for so long, we've had a complete mess. It has worked completely opposite. They may be able to point to some wins here and there, what looks like wins, but I would say this has really contributed to the size and growth, the constant growth and power of the central state. Anyways, I did that episode over on Monday, Constitution 101 Enforcement Mechanism. You'll find that, plus all the other stuff that I'm mentioning here, Mike Meharry's article, that wiki page, the full Supreme Court opinion. Alan Mosley will get the blog post organized for this with all the links and all the different platforms we're on, and I'll get it published here on the site a couple hours after this live stream is done, 10thamendmentcenter.com/path-to-liberty, in case I haven't mentioned that one enough. And while I'm here taking a quick break, I want to say a quick hello to everyone out in the live chat. I really appreciate you being here, whether this is your first episode or you've been here for every single one since day one. Rights are not tradition. Desperation leads to despotism. Man, that is a great quote, which is used to expand the state. And I think people are desperate to find ways to stop government power. Mind you, so much of this is going to get me off on a quick side quest here, but so much of what the states do that are terrible are often either sanctioned by the federal government, sanctioned by the federal courts, or funded by the federal government. So much of the drug war, for example, even though a vast majority of arrests are made on a state and local level, so much of it is funded by federal grant programs, joint task forces, working with the DEA, the FBI, the ATF. They're all in on this. And if it wasn't for the federal government pushing things in this direction, I would say we would see much less of it in the first place. And then they have the federal equitable sharing program where when states actually end civil asset forfeiture, the feds just say, oh, just pretend. They don't say just pretend, but they basically say, well, just say that this is a federal case. We've got tons of federal laws on the books. There's tens of thousands of regulations. Almost anything you can stop someone for on the highway, you can find a federal law that they're breaking. There's even a book about it, 3 crimes a day. Everyone's probably breaking 3 federal laws every single day at some point or another. So it's very easy to say that. As soon as you say it's a federal case, now you're part of a joint task force. You're, in essence, deputized as a federal agent, and then you don't have to follow state law anymore. You can follow the federal program, the federal civil asset forfeiture program, and you can still take this stuff. So civil asset forfeiture is not just sanctioned by the federal government, even though we hear some people talk about how federal judges think it's a bad thing. They don't stop it. And on top of it, the federal government itself, the Department of Justice, is encouraging states to do this all the time with their cash, by giving them money and by having this program for them to participate in called equitable sharing. That's a quick side note, but that's I just wanted to say hi to everyone in the chat, and I got distracted. See how you guys could throw me off here. But hopefully that's interesting. There's Crew Chief Kirk Morrison, Cheriton Farmer, Liberty Gal, Haji, Rick in Michigan, Shock Jara is out there, Sparrow Dynamics, Winged Eternally, Blue Sky, been a while since we've seen you. Good to see you here. Mr. Boston is a pretty great name. That's where my sister lives, in Boston, but she's not Mr. Kirk Morrison. I'm sure I'm reading a few people a couple of times, and everyone else that I missed, thank you so much again for being here. I hope you're enjoying the episode so far. But let's get right back to this. So anyways, what happened was the Indiana Supreme Court said, no, the federal courts haven't told us that the Eighth Amendment applies to the states. We can't even consider the state Supreme Court, the state constitution, because, well, even though everyone thinks it's an excessive fine, and I'm not sure what the Indiana Supreme Court said about it being excessive or not, but the two lower courts certainly took a position that this was wildly excessive. And I think if they would have just sued under the state constitution, it's very possible they would have won. And if they didn't, that's a different problem as well. But so after the Indiana Supreme Court, Timbs and the Institute for Justice appealed to the Supreme Court. And here from Wikipedia again, Timbs petitioned the U.S. Supreme Court to hear his case, focused only on answering the question of whether the excessive fines clause, the excessive fines of the Eighth Amendment apply to state and local governments as through the due process clause. So this was 100% about trying to convince the federal government to stop a bunch of states from doing bad stuff. And almost all of the states are doing really bad stuff. But the question is the largest government in history, the biggest empire in history, the ones that are violating our rights 24/7, 365, and then paying the states to do the same, are they the ones to protect us from their vassal states? I think that's a dumb strategy, to be honest with you. I can understand going through the lawsuit to try to claim that something is excessive, but to try to make everything a federal case, I think is really actually giving us negative results. So, in other words, they could have just filed this under the state constitution, but here's a little bit more. Observers believe that on the constitutional questions, the justices were weighed heavily in favor of asserting that the excessive fines clause was another right that should be incorporated to the states. I think that was almost certainly was going to happen. Everybody thought that they were going to incorporate it against the states at that time, but there was some question. Well, we're not going to make any opinion on whether or not in this particular case this was excessive or not. However, they write, these observers also believe that while the question did favor Timbs's case, the court appeared to be ready to vacate the Indiana Supreme Court decision and rehear the case to determine if the forfeiture of the vehicle was to be considered as an excessive fine. Short version, the Supreme Court was just going to say, yes, this is an Eighth Amendment issue that's happening in Indiana. Just ignore that whole Bill of Rights in the state constitution. You don't need it. It's definitely a federal issue now, even though it's state police and the state government doing this, and the state constitution actually addresses this exact same thing with even stronger language on there as well. But don't even consider it under the state constitution. This is a federal constitutional issue. You state courts, now you determine if it was excessive or not. Well, they already determined that it was excessive, and maybe that would have ended the case at that point. Maybe some people have some insight into telling us that, well, they were going to rule against him anyways under the state constitution. I don't know, but it sure comes across to me that this was really all about just getting the incorporation doctrine expanded, federal power expanded, whether for good reason or not. So here's how Mike Meharry puts it. Thus, the Supreme Court's opinion obviously did not end asset forfeiture. It merely said that the states had to follow the excessive fines restrictions in the Eighth Amendment. And I think what happens in almost all of these situations, this is my view of it, and I should probably go into some more detail and provide some receipts on this, but the way I see how this generally plays out in many situations, when the federal government says all the states have to follow what the federal government tells them about not violating people's rights, what they do is they make it kind of a watered down version of it, like we see on the right to keep and bear arms and on surveillance. Well, you don't have an expectation of privacy, and then they all end up following this lower standard. They don't ever use it as a floor and really build upon that. Well, sometimes we've been pushing for that to happen, but what it creates is a lower standard for everybody. Maybe it's higher for some, but it's certainly lower for everyone else because they're saying, well, this is how the Supreme Court defined it, so let's roll with that. But in this situation, they didn't even touch whether or not this was excessive. This was going to be a decision for the state courts to make, and they could have made that right at the beginning and not had to gone through all these years of waiting in this process. So Meharry writes that the SCOTUS then sent the Timbs case back to the Indiana Supreme Court for it to determine if the forfeiture was excessive. In 2019, the state high court laid out criteria. So even at that time in 2019, they had a set of criteria to define what was considered excessive and then sent back the case to the trial court for that court to determine whether or not the forfeiture fit within those parameters. That court then again found in favor of Mr. Timbs, saying the forfeiture was excessive and ordering the state to return the Land Rover to its owner. So we had the same process. They already determined it was excessive all the way back in 2012, 2013. I think it was 2016. I'm not sure I think the first state court was in 2016 and then 2017. And then finally it got to the Supreme Court there and the opinion was released in early 2019. So they had already determined that was excessive. And then they had to go through a few more years of determining whether or not it was going to be the federal government saying it's excessive or the state government. To me, this is a bad process. The state, of course, appealed that ruling and brought it back to the Indiana Supreme Court, arguing that the trial court was wrong to call the Land Rover forfeiture excessive, and as Ilya Somin put it, quote, more generally that the state Supreme Court should adopt an approach to measuring excessiveness that is more favorable to law enforcement. So they wanted to really encourage more forfeiture. But in 2021, the Indiana Supreme Court finally settled the matter in this one case, in this single state. And by a 4-1 vote, they held that it was excessive. So that we know that it's almost certain that they would have viewed this as excessive in the first place, and Mr. Timbs would have gotten his stuff back years earlier. So this person had to wait extra years in order to establish a precedent expanding the incorporation doctrine. And then did it really even stop civil asset forfeiture? Now we're still set in the same kind of a scenario. So by a 4-1 vote, Mike writes, the state high court held that based on its own criteria, not federal court's criteria of excessive, but its own, the state shouldn't have taken the Land Rover. Doing so was excessive because the value of the vehicle was 3.5. Well, it's more than 4 times the maximum fine for his offenses. So the whole thing reveals a problem with trusting the federal courts to limit really anything. And first of all, let's go back to Ilya Somin. He said, while this result is a happy outcome for Timbs, this is in 2021 when he wrote this, it may have only limited impact on other asset forfeiture more generally. In other words, all these court cases, and it's doing nothing to really end civil asset forfeiture. The court emphasized that only, quote, grossly disproportionate forfeitures qualify as excessive, and that such cases are rare. So according to the precedent established in Indiana, it has to be grossly disproportionate to qualify, and there aren't many cases like that. So this whole court process, state court suing under the federal Constitution, then finally getting up after 3 courts reviewed it, then going to the Supreme Court, and then back to 2 different state courts. This has really resulted in the guy getting his stuff back and really no massive change whatsoever. I would say it's pretty negligible in how excessive fines are viewed in any of the states at this situation. And Somin actually points out what might be even worse through this whole process. And I think he's actually he certainly is supportive of using the federal court approach here. I think he probably would want to. My guess is he'd probably want the federal courts to come in and tell everyone, give a standard for what is considered excessive. And then again, of course, they'll water that down over time, and then everything will be considered not excessive over time, and maybe those cases will only be rare. If we see how this high court, and as Brian McClanahan has pointed out, the state high courts are really on equal footing with the federal high court, so as far as their impact in their own sphere. And so if they look at it like this, these top-notch legal minds that sit on the bench, why would the federal courts be significantly different? Sometimes it happens, but I would think that it would lean towards this same approach. So while some may worry, he writes, that this will enable defendants to keep property they supposedly should not, I worry that lower court judges sympathetic to the war on drugs, which accounts for a high percentage of asset forfeitures, can use the test in ways that make it very difficult for property owners convicted of drug offenses to ever get a forfeiture overturned. Again, it's still the same process. They take your stuff, and you have to prove to them that they shouldn't have taken your stuff. So the presumption goes towards the government in the first place. And if you have to rely on that rather than just saying we're not going to participate, the state is no longer going to do civil asset forfeiture, you're always going to have to go through this process. Mike Meharry points this out, that this same process, because again, this only applied to this one individual in one state. Now, maybe this is the new precedent for Indiana, and it's actually not really that awesome. So they should just end civil asset forfeiture by the legislative branch in Indiana, because they have to deal with this situation going forward. But this same process, Mike writes, will have to be repeated in every single forfeiture case in every single state It's clear the SCOTUS decision in the original Timbs case did nothing to end forfeiture. It just further muddied the water and complicated the legal process. And I think this could have, like I said, this could have been resolved for Timbs in his favor years earlier, because we know that all three of those Indiana state courts viewed this this forfeiture as excessive. And so the whole thing was really about that precedent. And I think it's possible that some people, because some people wrongly believe, and as you saw that example of Sarah earlier, we get this all the time. Like, why are you doing this? The Supreme Court already ended civil asset forfeiture. We hear it all the time. And because some people wrongly believe that the Supreme Court ended civil asset forfeiture, they no longer do anything to support efforts to restrict civil asset forfeiture on the state level. And then sometimes they even go out of their way to oppose those efforts, say, this is redundant. This has already been done. There's no need to pass this. This is a waste of time. And so that means in some ways, in practice, things actually might be worse because they took this approach to expand the incorporation doctrine and use the federal government to protect people from something that the state constitution already said they couldn't do. Now, maybe I go a little bit over the top on this, because I think it's a terrible strategy to go to the federal courts to protect you from the states, because most of the stuff that they do comes from the federal government anyways. But I do agree with Mike Meharry here. He says this underscores an important reality. We cannot rely on federal courts to protect people from these abusive and unconstitutional asset forfeiture processes. The only way to do that is to reform and eliminate state asset forfeiture laws and opt the states out of the civil asset forfeiture program from the federal government. Equitable sharing. Opt the states out of a federal program that allows them to bypass more stringent state laws by passing cases off to the feds. Well, I hope you guys found this interesting. It's kind of a mouthful today, and I hope I did a decent job explaining my view on this. Whether you think I'm on it or I'm stupid, I would love to hear your thoughts on this whole process and the strategy that was used and where we are on civil asset forfeiture. Of course, leaving comments, whether it's live or in the archive, reviews on Apple Podcasts or any other podcast platform, those things certainly help us reach and teach more people with this information. It gets people, maybe we're just reaching people and getting them to think about stuff. Think about it from a different perspective. But every time you do that, it can also, leaving those comments and taking all those actions, subscribing, getting notifications, all those things can help trigger the algorithms of the mainstream platforms and tell them to show us to more people. There's also our membership program. If you got a couple of bucks of that dirty government fiat, throw it our way over at 10thamendmentcenter.com/members. Again, 10thamendmentcenter.com/members. I don't think anyone punches above their weight class better than the 10th Amendment Center. And you can support us and our work with your financial faith for as little as $2 a month. We also have annual, 5-year, and lifetime options over there as well. I will take a look over in the chat a little bit later today, or maybe sometime tomorrow. I see some comments. There's Alan Mosley. I think you're on it, boss. Well, thank you, Alan. If I'm not, you're in trouble, right? I appreciate that, though, Alan. Thank you so much. Sonny Bono says, always an awesome show, Michael. I hope you enjoyed it as well. I appreciate your feedback. Courts acting as an injured party, said John. I'll have to read through more of this a little bit later today. I get a lot of great ideas for future episodes. Sometimes people challenging me, pointing out things so that I made a mistake on, something maybe I didn't cover in enough detail. So thank you so much for all your feedback, whether it's live or in the archive. You can also email me at team@10thamendmentcenter.com. Again, thank you so much for watching or listening to the show. I probably am going to be off on Friday, and that's a heads up to you as well, Alan Mosley. I'm probably going to be off on Friday because I've got some family stuff off and on throughout the day on Thursday. So it's 50-50. I guess we'll just see how it goes. If I'm not doing the show on Friday, I will definitely be back next week, Monday, for the regular schedule. Thank you so much for being here. Hope you have a great day. Hope you enjoyed the episode, and I hope to see you next time, whenever that is, here on the Path to Liberty.